Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, we are here on State versus Joshua Andrew Garden, and after meeting with the state and the defense lawyer, it was indicated that there are numerous motions that are needing to be heard, but the first motion that logically needs to be dealt with is the motion to disqualify the district attorney's office, if I understand correctly. So we will hear your motion, and Mr. Garten needs to have a seat at the table over there, and I'll hear your motion, and we'll consider that motion first, and then we'll move to anything else. If I grant that motion, then obviously it may necessitate the designation of a separate district attorney, and we'll have to then reschedule everything else. So, all right, Mr. Garten, if you'll have a seat there. All right, it's your motion to disqualify, so I'll be glad to hear your argument.
Thank you, Your Honor. In this motion to disqualify, it is essentially a motion, we're talking about fairness here and the appearance of impropriety, but not just the appearance of impropriety. In the old Code of Professional Conduct, appearance of impropriety was enough of a standard to have a case dismissed, right? Could a member of the general public look at a situation and say, this reeks of malicious prosecution, or this looks like it could be unfair? The rules of professional conduct, and this is backed up by case law from last year, now holds that the mere appearance of impropriety is not enough to disqualify a case, that you need something else besides just, this doesn't look good. And so we would say in this matter, there's been actual impropriety. On behalf of the district attorney and the Dickson County District's office. In January 2021, this is quite a well-known case in this area, Mr. Garten was arrested for posting a meme online of someone desecrating a Dickson County police officer's grave. He was jailed for 12 days on that, on a harassment charge. On his first court date in general sessions, it was dismissed for lack of probable cause. A couple months later, in April 2021, he filed a lawsuit against a number of entities and individuals, including the district attorney, General Crouch. That lawsuit alleged malicious prosecution, false arrest, First Amendment violations. The official capacity claims against Mr. Crouch were dismissed, but the personal capacity claims the court declined to dismiss. And that subsequently led to Mr. Crouch and a couple of TBI agents settling for $125,000. In 2024, Mr. Garten was arrested and ended up pleading guilty to an amended charge of sexual exploitation of a minor in Dickson County. He's currently on probation for that charge. This year, he was arrested for 15 counts of rape of a child and 1 count of continuous sexual abuse. And so that brings us here today. Actual past impropriety directed at and suffered by my client irreparably taints any subsequent prosecution of him by this district attorney and this district in particular, the one that originally tried to prosecute him on that 2019 case. I think as an outside observer, no one could be sure of the fairness of these. They would look at $125,000 is not a small amount to have to pay in a personal capacity. And so if I'm the district attorney or if I'm a member of the public and I'm looking at this office repeatedly coming after my client, I would say that kind of seems like there could be a personal vendetta against it, right? And so we're not just looking at the mere appearance of impropriety again, but there has been actual past impropriety. So that's what we're trying to preserve here is the interest and appearance of fairness. That is quoted in a Tennessee Supreme Court case, State v. White, that was quoting a Supreme Court case. In that Tennessee case, the standards of the profession, the court said, mean that all legal proceedings must appear fair to those who observe them. And so it's not just enough for us to say in our legalese, they did this right, they did that right, we understand the charges. This is about how does the public look at our justice system? And could you, again, look at this case and think, there's something else behind this besides maybe evidence in the case, okay? Tennessee Rules Supreme Court, I quoted on page 4 of this motion, a lawyer should further the public's understanding of and confidence in the rule of law. And so confidence in the rule of law in this matter could be easily shaken knowing the past impropriety suffered by my client. There's simply no way that further prosecution of him could be viewed without suspicion by an outside observer. And so what are we trying to preserve here? Again, the appearance of fairness. And so say we disqualify Mr. Crouch from having any participation in this. So we're going to implement a screening process. That is not enough in this because of his position, not just as a district attorney, but the district attorney overseeing this office. And so we can't screen something intangible like authority, right? Or sway, or I don't want to be the DA who, has to do something in this case that I'm worried about how my boss is going to react. Simply isolating a boss is not enough. Again, it's the intangibles that come from his position as a district attorney that are in play here. When evaluating this matter, there's really only 2 questions that Your Honor needs to ask and answer. Does this appear to be wrong? Is there appearance of impropriety? Yes, and again, not just an appearance. And so if there is, should the district attorney's office be disqualified? Again, yes. I don't know how you separate the district attorney from his office and the assistant district attorneys that are under his purview. And so I think that, again, in sum, there is more than the appearance. There's an actual impropriety in his authority and position, meaning it's not enough to just disqualify Mr. Crouch from participation in this matter. It should be imputed to the entire Dickson County District Attorney's Office. And that's what I would submit to Your Honor.
So if I'm understanding you correctly, Mr. Garden, after these events that took place that you have described regarding the meme that he filed and the prosecution and the later dismissal and the later resolution of claims that resulted in a payment to him, after those matters took place, Mr. Garden was prosecuted in this county for a sexual offense and was convicted and was placed on probation.
Pled guilty.
Correct.
Sure.
And in that particular instance, did he raise the same issue about the disqualification of the district attorney's office?
The district attorney, actually, Mr. Brooks, General Brooks told me today that actually he had raised that issue and then it had been denied. I would say, again, if we're looking at the appearance of fairness and I'm an outside observer, I'm thinking, oh, they got him once and they're going at him again, right? And so this is not just how we look at it. This is not an evidence thing. This is an appearance of fairness, confidence in our justice system. Can we be sure that a DA who has already gone after this guy once isn't just going to keep hammering until he gets what he wants, right? We got probation the first time. Now he's going after prison time. I would submit that the charges that he's faced with are extremely serious and carry quite the public stigma.
All right, thank you.
Good to go. Thank you, Your Honor.
Mr. Brooks?
Pass up an order by the Middle District Court. Enter that as an exhibit in this motion. Essentially relieving all parties of liability from that civil complaint after reaching a settlement. No wrongdoing was found on the record, but the state would concede that a settlement was reached. General Crouch was sued under the in his personal as the person Ray Crouch and in his capacity as the district attorney. He himself did not pay any amount in settlement that was reached with the DA's conference, and the DA's conference paid those amounts. I'm sorry, Judge. The Attorney General reached that settlement and paid that settlement amount. I apologize. General Crouch was not
Attorney General for the state of Tennessee.
For the state of Tennessee. General Crouch was not found in liability of any of these complaints. As the court mentioned before, Mr. Garton has filed a similar type motion twice before in a different case, 2019 CR 155 in front of this particular court. Once, all have been subsequently denied. once before the potential litigation, before any complaint was actually filed, and the court denied that motion to disqualify. And then further, after the complaint had actually been filed, Mr. Garton refiled his motion to disqualify, and the court again denied that with an order. The court cited the concern that the potential floodgates that would be opened if the court were to disqualify this office for any subsequent prosecutions of individuals that filed civil claims against them. Because essentially, if you didn't like this office prosecuting your case, you would just file a civil complaint. And that would, that way you could cherry pick whatever office. If you didn't like your offer, if you didn't like the way things are going, you just file a civil complaint. And the state agrees with that notion that disqualifying our office would open up the floodgates. No wrongdoing was found in the previous case. It's also important to note that these allegations have nothing to do with that incident of harassment that the civil litigation was subject to. I personally, I'm the assistant DA on this case, prosecuting this case. I don't know Mr. Garton from Adam Reeve. I wasn't with this office when this harassment charge was taking place. I absolutely had no idea who he was until this file was on my desk. And I personally do not feel any pressure to prosecute this case in any such a way. And I feel that I'm able to evaluate it fairly and to make offers and to prepare this case for trial if it's unable to come to a settlement.
Anything else? As previously pointed out, Mr. Garton has, subsequent to the facts and things that occurred, the instances of it that occurred that led to his being arrested on this meme situation, and subsequent to that case being dismissed and his having instituted a civil lawsuit, this court considered the motion to disqualify the district attorney's office and put an order down, and I stand on that order. The district attorney's office is a constitutional office that is charged with ensuring that justice is done in prosecuting cases that there is a factual basis or probable cause for the institution of a criminal action. In this case, Mr. Garton appeared before the court some time ago after, again, those things that took place with the civil litigation. And that issue was raised. It was denied by this court. I find there's no difference in this situation that we're in today than what the order was that I put down before, and I would adopt that order as a part of this file as well. In this particular situation, Mr. Garton is charged again with sexual offenses. Counts 1 through 15 are charges of rape of a child. Count 16 is a continuous sexual abuse charge, which is a very serious charge, obviously. Those charges are not in any way related to the situation that occurred before. They do not arise from the factual basis of them, to my knowledge, do not arise from the facts that occurred in the prior case that led to the civil litigation, and they were initiated as indicated by the the Dickson Police Department. Detective Katrina Pooley was the initiating agent for that, so it doesn't appear that General Crouch had any involvement in that whatsoever. So I am of the opinion that the appearance of impropriety in this case does not rise to the level that would require the district attorney's office to be excused or recused from this case or disqualified from this case. And again, there doesn't appear to be any actual impropriety, because the civil litigation that was concluded by Mr. Garton voluntarily through his lawyer indicated that there was no wrongdoing and there was a release of liability without a finding of any sort of fault. It was just like a car wreck that parties resolve a case and find that they agree to a settlement without admission of liability. So based upon that fact and my ruling in the prior cases, I'm of the opinion that those motions, the motion to disqualify is not well taken and should be denied, so I respectfully deny the motion. Now, Mr. Garden had a number of other motions that we were trying to get heard, and it may be possible if you'll wait around, Mr. Yeager, I may be able to give you a date of Wednesday of this week if all goes well in a few minutes, okay? Would that Wednesday be possible for you to hear those other motions, Mr. Brooks? You want to hear them all in one day?
I would probably prefer to hear the 404B with the FI as well. I think some of the proof will be overlapping.
All right. So how much time do you need?
I think it will take no more than 2 hours, and that's just being conservative.
Well, I'm talking about how much time do you need to prepare?
Probably at least a couple months, Judge, to give Mr. Yeager time with it.
What about December the 24th?
Did you tell me to be here? I will be here with a Christmas sweater on.
No. I'm not going to do that. So. Well, you're looking at January then, because unless we hear it out of county, but even then, we're already hearing a bunch of stuff out of county that can't seem to be. State versus Cordarius Godwin, is that still a go for the 6th and 7th of November? State versus Cordarius Godwin, 6th and 7th of November. Still a go?
Yes, Judge.
Judge, I am fine with January if the council is. It's completely up to the court, but, you know, I know we were talking about if we're unable to come to an agreement.
I think the only thing I can do is set you on the 9th of January. That's the day I set those motions in that daycare case out of Stewart County. So I will set the motions on that day as well. And I think that's probably all we'll be able to have heard that day, so. All right.
And then, Your Honor, one of the motions was a motion to set bond. So we have the forensic interview and the 404B in January would be great. But if we have an earlier hearing date for his motion to set bond, I would appreciate that.
Motion to set bond.
I could be as, I could have a detective here whenever. Oh, we had a witness that did not show up today.
Dental emergency. She's ready to go after Wednesday.
What about the 29th? Well, we don't hear on the 29th, may get bumped to another day, but. Let's set it for the 29th and be flexible enough that if it shouldn't take that long on a bond here.
It should.
All right, we'll set it for the 29th.
Judge, on the record, I need to strike my notice that I filed with the court as far as the sexual abuse, the notice that's required by statute. There were some typos in that notice, and I may need to adjust the address after talking with the victim. So I would like to strike that notice. I'm still well within the statute.
All right, then your notice is stricken. You can refile if it's within the time limit.
Thank you, Judge.
Thank you, Your Honor.
All right, are we ready on Wills now?
Yes, Judge.
All right, bring out Mr. Wills again, please.